Understanding DUI and DWI laws, sobriety checkpoints, and DUI/DWI, Part 1. DWI, driving while intoxicated, and DUI, driving under the influence, are phrases that both novice and seasoned drivers may find perplexing. Both terms apply to operating a motor vehicle while under the influence of alcohol or drugs, and they are frequently used interchangeably. The phrase driving while intoxicated was first used to make it simpler to prosecute drivers who are under the influence of alcohol. While it may not always be clear what constitutes impaired driving, all 50 states' legal definitions of intoxicated include having a blood alcohol content, BAC, of 0.08% or higher. Therefore, whether or not a driver exhibits symptoms of intoxication, they will be charged with DWI if their blood alcohol content, BAC, is 0.08 or higher. Many states distinguish between two distinct cases of intoxicated driving using the labels DWI and DUI. In some situations, driving while drunk, DUI, may relate to driving while under the influence of drugs, DWI, or vice versa. By consulting the state's penal code or the materials from your driver's ed course, you can learn how these phrases apply to impaired driving violations in your state. Below are a few state-specific examples of DUI and DWI regulations. In other places, the terms impaired and drugged are used interchangeably to refer to various degrees of intoxication. Driving under the influence in this instance denotes a milder level of intoxication and is seen as a less serious offense than DWI. Drivers in these areas who have blood alcohol levels above the legal limit are typically prosecuted with DWI, a more serious crime. The convicted motorist may be given the option of accepting a plea deal that would change their conviction from DWI to DUI, depending on the gravity of the incident. Drivers who are visibly intoxicated but are not over the legal BAC level cannot avoid arrest thanks to the distinction between DUI and DWI. The following circumstances will result in a DUI or DWI accusation against you. If your BAC is 0.08% or higher, or you tested positive for illegal substances, and/or you're showing symptoms of impairment. Usually this means performing poorly during a field sobriety test. WI and DWI. Two additional acronyms you could go into when talking about impaired driving offenses are WI, operating under the influence, and DWI, operating while intoxicated. These legal concepts are used by Maine, Massachusetts, and Rhode Island to prosecute drunk driving offenses. In certain situations, the offender may be penalized for no more than having the engine running while parked than being intoxicated or under the influence of drugs or alcohol. Alcohol checkpoints. Sobriety checkpoints are a common strategy used by authorities to catch and discourage drunk drivers. Police officers will set up a roadblock on a public route at a sobriety checkpoint and randomly choose some drivers to be tested for signs of alcohol or drug impairment. This could involve inquiries, a field sobriety test, a breathalyzer test, or any combination of the three. Federal law requires that sobriety checkpoints be publicized before they are set up, often on the radio, in a local newspaper, or with signs placed on the road itself, and must select drivers at random. Police officers frequently predetermine a schedule to follow when testing drivers, such as every fifth vehicle, in order to keep the process random. Currently, neither Alaska, Iowa, Michigan, Minnesota, Oregon, Rhode Island, Washington, Idaho, Texas, Wisconsin, Wyoming, nor Montana perform sobriety checkpoints, though Montana does allow safety spot checks. States that forbid sobriety checkpoints typically do so because they think the practice is unconstitutional under state or federal law, or because random searches are prohibited by their state's constitution. BAC and DWI laws. To give you an idea of how they differ, the following are some instances of the laws regarding DWI and DUI convictions in a few states. The phrase, driving under the influence, DUI, is only used in Texas to refer to children who are found to be behind the wheel while intoxicated. A person under the age of 21 is considered affected by alcohol if their blood alcohol content, BAC, is 0.01% or more because it is illegal for them to drive while having any level of alcohol in their system. All other drug and alcohol-related intoxication convictions are referred to as driving while intoxicated. If an adult motorist has a blood alcohol concentration, BAC, of 0.08% or above or is affected physically or mentally by alcohol or another controlled substance, they will be charged with DWI.